I'm joined by digital, gender and media rights lawyer Mojirayo Ogunlana, who was part of the team representing applicants. Thank you very much for joining us.
Thank you. Good evening.
A very good evening to you as well. The court dismissed the allegation that the right to life was violated, but upheld the federal government committed several human rights violations. In brief and for clarity, please explain the violations that were upheld and what the judgment means.
Okay, so while you were narrating what happened in court today, I'm aware that the media team of the court had misrepresented the compensation that was paid to each of the applicants. Now, in responding to your question, the right to life was not upheld.
Could you please go back? Sorry to interject. Could you please just go back to the compensation you talked about?
Okay, so for every violation, the court pronounced compensation of 2 million naira each, and the court held that there were 5 violations. So each of the applicants was awarded 10 million naira each. So it was a total of 30 million. So it wasn't the 2 million that is being carried as at now. So the court first held that there was torture, and that the situation at Lekki Toll Gate put the applicants in fear, and as a result of that, it found that the Nigerian government violated their rights and their rights to human dignity, and he held immediately that each of the applicants was entitled to 2 million naira compensation for that particular violation. Then he went to the violation of their right to freedom of expression, right to assembly, and right to association. And the court held that it found Nigeria in violation of this right, and so awarded 2 million naira compensation each for the applicants. Then the court went further to say that the Nigerian government did not make reparations to the applicants, and so still held that they were to be compensated for that particular violation. Then, of course, it didn't give them access to effective remedy, and then the court also held that there was a violation and held that they were to be compensated 2 million naira each. And then the court finally held that the Nigerian government failed in its obligations, and of course, it still held that they were to be paid 2 million naira each for that particular violation. So it came down to 10 million naira each per applicant. So I was in court, and that was exactly what I wrote down, as the rapporteur was very specific when delivering that particular judgment. So it was misrepresented and
It is disconcerting, to be fair, that the amount that's being put out in the media is 2 million, whereas it's more than that. Thank you for that clarification. Let's talk about the federal government paying these monies as compensation for violations. Has there been a response from the government yet?
Okay, so I should say that when the judgment was delivered today, the government was not represented. So the lawyers in court were the lawyers for the applicants and the amicus curiae, and the amicus curiae was Amnesty International. The respondents was not represented in court. So they will be getting the news exactly the way every Nigerian will be getting the news, because they failed to show up despite having the hearing notice from the court.
So at no point during this trial, during this case, did the federal government, did anyone represent the federal government?
Okay, so the case was filed since around December 10th, 2021. And by the rules of the court, the respondent had 30 days to respond to our application. So we were trying to be as nice as possible, because after 30 days, we're supposed to file for under the Article 90 of the rules for a default judgment, but we waited. We waited all the way till 2023 because we wanted to hear from the government. We believed that we didn't just want a default judgment, and we wanted that the Nigerian government to come and defend itself.
Well, I mean, it's curious though. How can sorry to interject, but I have to ask this. How can a judgment be binding on a client that was not represented in court? And we know that this is not the first time the ECOWAS court will be giving rulings about cases of human rights violations.
That, right? They came in 2023 and asked for opportunity to be heard. And they presented their case in 2023, where largely the defense was that the protesters were hoodlums and unlawful people gathering together in some places, and then also came up with this spurious idea that the soldiers and the police shot into the air and not at the at the people. But unfortunately for them, we had uncontroverted evidence that went through forensic forensic analysis. Yes. And then we presented all that before the court, where it was verified. All the videos that were presented in court were verified to be
this is actually more about I'm sorry to keep interjecting, but I wanted to get out the key point from you. This is more about because it's going to come for my next question, which is compliance. The government has, on several cases, gotten ruling from the ECOWAS court, which they never responded to. What gives you the, maybe the mind that the federal government will comply this time, asking them to pay for violations? See how long it took them to even represent themselves.
Okay, so I know that there is always this bottleneck or this issue with compliance, but that was largely under the Malami administration as the AGF. We have an AGF that has proven so far to be. In fact, when I got the judgment in the Delegiwas case, where they said they should reopen investigations into Delegiwas and other journalists that were killed, I remember that the office of the AGF contacted me directly to ask me questions, and it showed to me that the AGF's office is actually being very effective. So I'm believing that this will be the case, because the court had already even stated that if the Nigerian government do not respond to or allow us to implement its judgments within the next 6 months, we would write back to the court. We would attach it we'll write back to the court, copy the AGF, and then copy the ECOWAS Commission, so that it will be an issue of sanctions to the Nigerian government. So we're not going to just sit on our oars and think that this judgment will not be
okay, but let me also clarify something quickly. I'm told we're out of time for this conversation. The court did give a time frame, 6 months, I beg your pardon, to facilitate the implementation of the ruling, have the federal government investigate its agencies. What is the likelihood that this will happen in the first instance, and what would the court do to sort of enforce its ruling?
Okay, so I know, that's what I was trying to explain to you, that I want to believe that the new AGF is different from the previous ones. And there have been judgments of the ECOWAS court against the Nigerian government that actually the AGF's office has complied with. I know, for instance, that a lot of judgments gotten by Femi Falana SAN has been implemented. They always paid compensation. So this particular case is not a case that will be swept under the carpet, because, for instance, we are in the right path by having this kind of media engagement, and the government doesn't want to be embarrassed and over 30 million naira. I think that they can do better than that, and I believe that this particular case will be one of those cases where they would pay, because they had complained in the past that the ECOWAS court had awarded huge amounts of monies. And so now I think this 30 million is coming from the perspective of the court trying to reel out enforceable costs or enforceable compensation against defaulting states. So I'm very hopeful about this particular one.
Thank you very much for speaking with us and for the work that you do. I don't think you get enough thanks for it. Thank you.
Thank you.